Hello, everyone, and welcome to the latest of our joint Youth Justice Legal Centre and Doughty Street Chambers Children's Rights Group events to launch the latest of the joint legal guides. This one is on police bail and remand for children. And we're joined today by a superb lineup of speakers who Katia will introduce to you in a moment, who've been at the heart of work on this issue for many years, and in particular, since 2016, when a series of legal challenges against the practice of detaining children in police cells, despite there being a clear legal framework saying that should not happen, has been challenged in a series of cases by the very lawyers who join you today. So I just wanted to welcome you on behalf of the Children's Rights Group and hand over to Katia, who's our chair for today, co-head of the Youth Justice Legal Centre, part of Just for Kids Law, who has been doing such groundbreaking and campaigning work on this vitally important issue. So welcome, and over to you, Katia.
Thank you so much, Keelan, and it's a pleasure to be here launching the 9th guide in our series, and a big thank you to the Children's Rights Group at Doughty Street. It's been great to collaborate on all of the guides so far, and yeah, I can't believe it's the 9th one actually. So today's guide, we should be able to have a look at a picture of it, if I can get the next slide, is on police bail and remand for children. And actually, in our experience, overnight detention at the police station can be, and often is, the most traumatic part of a child's journey through the criminal justice system, and that fact is often overlooked. By the time they get to court, everyone's forgotten about the fact that they spent the night in the police station, but it's actually a really important part of the process. So if you could just go to the next slide, please, Ray. Yeah, we've got a brilliant lineup of speakers today, and I will introduce them before they each individually speak. The first speaker that we're going to hear from is Jackie Bellfield-Smith. I'll tell you a bit about Jackie. Jackie has been head of Youth Justice, Serious Violence Reduction and Targeted Youth Support Services at Stockport Council since 2005. And she also holds a national position as the Vice Chair of the Association of Yacht Managers. Jackie's work has ensured close collaboration over many years between Greater Manchester Police and Directors of Children's Services to ensure that an operational joint PACE protocol is in place. The monthly scrutiny of cases aims to create a learning culture that equips custody suite staff and out of hours colleagues to make effective frontline decisions. So on that note, I will hand over to Jackie.
Hello, good afternoon, everybody. I've been having some problems with Zoom, so I'm hoping it's going to behave for me for the next 10 minutes. So first off, thank you for inviting me to speak to this bail and remand webinar. I think it's something that we've been working on for a number of years. As I've said, I am Head of Youth Justice and Targeted Youth Services for Stockport Council. I'm also the Vice Chair of the Association of Yacht Managers, and in both positions I hold the lead for children in police custody. However, what I want to talk to you about today, next slide please, is the Greater Manchester experience, because we have been on that awful word, a journey, but I just wanted to give you some sort of insight really into where we were and where we are now, and just thought it would help in terms of anyone who's developing a different approach to children in police custody. So it's worth saying I'm not a lawyer, work with a lot of lawyers, but I'm not a lawyer and I'm not a police officer, but we do work very closely in partnership. So Greater Manchester, for those of you who don't know, it's 10 local authorities: Manchester, Oldham, Wigan, Stockport, Salford, Bury, Rochdale and Tameside. We've got 1 police force, Greater Manchester Police, 7 operational custody suites, 2 what they call mothballed suites, and counter-terrorism suite, 1 probation area, and then we sit under the mayoral administration for Greater Manchester Combined Authority. Next slide, please. So where we were back in 2011, GMP had one of the highest numbers of overnight detentions in the country. We used to receive the monthly list, and there were up to 100 children being held in detention every month. And there was just a lack of availability, so we were unable to transfer children under PACE. There was just nothing available, and children were just being held overnight. This was then reinforced by an HMRC inspection that was carried out in the custody suites across Greater Manchester, which was really critical of some aspects of practice, not just for GMP, but with all the custody suite staff and local authority staff and the appropriate adult service. Anyone who wants to read that report, it's called "Who's Looking After the Children?" It's you know, a very good read, but it made us think differently about how we should approach this. Next slide, please. So we took a decision at a senior level across the 10 Greater Manchester local authorities and with GMP to pull together a working group, because we felt that we really needed sort of a root and branch about how we were going to deal with children in police custody and reduce the numbers. So initially, this was with the directors of children's services across the 10 authorities, senior officers from GMP, and the 10 heads of the Greater Manchester Youth Justice Services. And then latterly, as it's developed, it's included the combined authority, the mayor administration, integrated healthcare, liaison and diversion, our out of hours colleagues, complex safeguarding, our appropriate adult service provider, children's society, and other relevant partners. Next slide, please. So we had set our objectives, and these were our objectives, and they were quite simple really. Reduce the number of children who are unnecessarily detained in custody, reduce the length of time that children spend in custody if they are brought in, improve the custody experience from the perspective of the child, and ensure that national standards are being consistently applied across GM. Next slide, please. Okay, so then we set our principles, which was to engage with children to inform and shape services. That was really critical because it was so important to listen to what children were telling us. Keep children out of custody where possible. Make sure that custody decisions were proportionate. Keep children in custody for as short a time as possible, or not at all. Affect a cultural shift, which, as you can appreciate, is really difficult. Work with partners in that custody, ensure an appropriate outcome and support in place for exit, employ a consistent approach across all the custody areas across the 10 divisions, and then be ambitious and challenge ourselves. Next slide, please. So in terms of the scope and governance, we looked at pre-custody in the custody suite, in the custody cell, and then release and transfer from custody. And we felt it was really important to start to look at our governance and oversight arrangements, and then to ensure that we continue to report those through to a senior level with the mayoral administration, Greater Manchester Police, and with the directors of children's services. Next slide, please. Okay, so in terms of our activities, we undertook these initial pieces of work. So we had informal interviews, and then there was national guidance and good practice that we wanted to review. We wanted to really look at the voice of the child, so that we were listening, and those voices were informing and shaping our services. There was a lot of data analysis and process mapping, right from when a child is arrested right through to post police custody, and then getting our governance and oversight right. All that sounds quite a lot of work. It was a lot of work, but you know, we just had to know what it was that we wanted to achieve. Next slide, please. So the outcomes were, and I'm looking at time here. So since 2011 and where we are now, obviously that's a 10-year time span. And this kind of pretty much sums up most of the work we've done. But I have to say right from the off, we are not there yet. We're nowhere near there. You know, we've done a lot of work, but we haven't done everything that we could do yet. We've developed a joint GM PACE protocol with GMP and the local authorities, which has been jointly owned by all of Greater Manchester. We've just reviewed it, and we always review it if there's new guidance coming out. We contributed to the Concordat in police custody, and there was a GM example in there about how we did things differently. We put out a tender in 2017 for a GMP for a single provider for our appropriate adult service, because our appropriate adult service was really piecemeal, and police were really struggling to get hold of people from local authorities. And so we have a one-stop shop now. We have one provider, and it's made a significant difference because it's one phone call and there's appropriate adults for the whole of Greater Manchester. We have a named senior lead now in GMP for child-centred policing. We've got a jointly commissioned integrated healthcare provision and liaison and diversion. And that integrated health care is in every custody suite 24 hours a day, 7 days a week. We did the participation work through some independent providers, Call and Voice, and the Children's Society, which listened to the experience of children so that could inform and shape the way that we work. We jointly delivered training, so that's between GMP and the local authorities, so all the new custody sergeants get specific training around children in police custody. We've jointly commissioned a Section 38 PACE bed, which is in Manchester and is used by all 10 authorities. We had a child-centred custody task and finish group. We have a monthly scrutiny function, and we also have a dip sampling. 25 cases every month are dip sampled and journey mapped to make sure that everybody is doing what they should be doing. We worked with GMP after speaking to young people about getting distraction packs in every custody suite, and that's everything from phone balls and whatever, because what children were telling us was, you know, there's nothing to do. And then we then put a call out across Greater Manchester to all the local libraries, and we said to them, you know, if you've got any books that you don't want, we're willing to take them. And so all those were vetted, and hundreds of books were distributed across GM custody suites. And then sort of finally for me really was the significant reductions in the number of overnight detentions. So I still get those numbers. And as I said, in 2011, it was up to 100 cases a month. And I can tell you that last month it was 8. So 8 children across Greater Manchester were held overnight, you know, which is a significant reduction, but we are not there yet. And we look at every single one of those cases, and we're constantly learning. And we just are asking ourselves, did we do what we could have done? Have we done things properly? And it's just, you know, we never give up. We'll keep working with children, and our ambition is to have no children in custody at all. So I think that's it from me, if I can pass back.
Thank you so much, Jackie. Yeah, it's really amazing example of what can be done, I think, and it's just evidence that sort of thinking outside the box and working together and being collaborative and perhaps more creative than one might have been in the past when thinking about how to work through these issues can really pay off. So thanks very much for that, Jackie. Our next speaker is Mel Stooks. Mel is a solicitor who specialised in youth justice work throughout her legal career, and she leads the youth crime team at GT Stewart Solicitors. She's an experienced trial advocate at the youth court, with lots of experience defending young clients charged with the very serious end of offences. Mel co-founded the Youth Practitioners Association and was a member of the ROOT committee that produced the advocacy and the vulnerable witness training. Mel has done her time in the police station and continues to represent children in the police station. dealing with a number of issues, including bail and remand and transfer to the local authority. So I shall hand you over to Mel now.
Thank you, Katia. One of the most important things we can do when representing children at the police station is make sure that they're not there for very long. And obviously the ideal situation is having a child turn up for a voluntary interview under caution where they don't even see the inside of a custody suite. But unfortunately, whilst that is on the increase, it's not the norm. And so we need to keep pressing the police to let these children out as soon as possible after they've been detained. Before charge, I think it's really important to keep pressing the police to justify the ongoing detention. If it's been authorised just for questioning, we really have to ask, why won't a voluntary interview suffice? It achieves the same objective. If they're being kept in overnight for interview waiting for an appropriate adult, why can't they be bailed overnight with or without conditions? I think many of you probably share my experience of a child being bedded down for the night because the appropriate adult can't attend, whether that's because a scheme doesn't send people out after midnight or whether because family members have got competing childcare interests. Children who go home and return the next day are obviously going to be better rested, better able to engage in the interview process and less traumatized by a night in custody. And of course, after interview, there is frequently ongoing detention whilst further investigations are carried out, interviews of co-suspects take place, or even for the file to be sent to the CPS. And really, there is no good reason for children to be kept in the police station while this happens. And we need to keep pressing for them to be bailed while these take place. And it doesn't justify detention at all. And when we're doing this, we're not just holding the police to the obligations under PACE. The police are one of the public bodies that are caught under Section 10 of the Children Act 2004. This made local authorities and their partnership organisations, including the police, responsible for improving the welfare of children. This includes their physical, mental and emotional well-being and protection from harm and neglect. So moving to when the child gets charged, there is, as you know, a presumption in favour of bail. Section 38(1) of PACE states that a custody officer shall order the release of a detained child unless one of the included exceptions apply. But what can we do to make sure that these children get bail? One of the most important things to do is to get the client's consent to speak to as many people as possible at the stage that we know the child is going to get charged. This doesn't just include the parents. We need to think about family members who could assist with an alternative address, other adults who would be deemed suitable to supervise those children if they were under a doorstep curfew and only allowed out in the company of nominated adults. People who offer addresses, are they willing to have a doorstep curfew imposed at that address? And of course, discussion about which is the most convenient police station to report to, which areas would form an appropriate exclusion zone. Children aren't generally very good at road names or knowing where they are supposed to be going. And so adults with better knowledge of their circumstances can assist with that. And one element that is quite often ignored when trying to put a bail package together is whether or not the client is already working with organisations, either on a voluntary basis or a preventative basis, such as the Youth Offending Service, because if they are cooperating with organisations outside of family and school, just sometimes that cooperation can tip the balance in favour of the child being given bail. One of the other things to note is where police use the exception of it being in their interests to be detained in police custody. There's no statutory definition of this. And I think it's very difficult to ever justify that it could be in a child's best interest to spend a night in a police cell if anywhere else is available to them. If we haven't been successful thus far and bail has not been granted, then section 38(6) of PACE kicks in. Should be pointed out at this stage that if a client is detained simply for breach of bail or on a warrant, then section 38 of PACE does not apply. But where they have been charged with a new offence, then it does. And 38(6) of PACE says that a child must be transferred to local authority accommodation unless 1, it is impracticable, and 2, that secure local authority accommodation is necessary to protect the public from serious harm, but isn't available. So at this stage, I think we all have to reach for the Home Office Concordat on children in custody. Really comes into its own at this point, so that we can make representations on a two-pronged basis to try and get the child moved to local authority accommodation. It's also worth knowing that there are regional protocols in place. They have been produced for each area and set out the decision-making process and have a number of useful contacts contained within them. So they've been produced for areas, they incorporate London, Greater Manchester, West Midlands, North Yorkshire, and they all contain very useful information that people at the police station should be able to have at their fingertips. So this two-pronged approach probably starts with the police. And the first discussion we need to have with them is which local authority they are going to refer the request for local authority accommodation to. The police can make this request of any local authority, and it makes sense if a local authority has pre-existing knowledge of your client to make sure that the request is made to them if they're not too far away, because they have the greater knowledge, the greater ability to find a more suitable placement. Then, of course, there is the discussion if the police are saying that it is impracticable to transfer them. Well, the Concordat defines what is impracticable, and it also says that an inspector has to sign this off if it's going to be given as a reason. Not only is that requirement set out in the Concordat, but it's also supported by the notes for guidance of Code C of PACE. Of course, the other reason for challenging the police at this stage is whether or not the secure accommodation is really necessary. Necessity to protect the public from serious harm is a very high threshold. Serious harm means death or serious injury, whether physical or psychological. And I think we've all had experience of clients who have been refused to transfer to accommodation because they've been looking for secure accommodation and it's just not appropriate. So they're the representations that we can make to the police. We then need to make contact with the local authority. And one of the most important pieces of information we can take to a police station is the contact details for the emergency duty team of children's services. If they're not included in your local protocol, they can usually be found on the local authority websites and on regional safeguarding partnership websites. They are a useful ally in this process because they may be able to persuade the police that non-secure accommodation is more appropriate, particularly if they have more information about the child than you have been able to glean, and they can assist in representations from that front. They are also able to confirm whether the police have fulfilled the Section 38 obligations, and they can update you on the processing of the request if it has been made. Of course, we then still sometimes have no success, and that at that point we need to be requesting a copy of the full custody record. That's because any contact made with the local authority should be recorded on the custody record post-charge. And we also need to request the juvenile detention certificate, as that sets out the reasons for the failure to transfer. Once we've got those documents, we can consider whether or not the ongoing detention in police custody is unlawful before making a decision whether or not to proceed with an emergency application for judicial review. And if we get to the point where all of those have been exhausted and we get to court the next morning and the child arrives in the cells from the police station, then we make a bail application at court. And very many children who arrive at court in the cells are granted bail from the court. It can be appropriate, I think, to raise this issue at court once bail has been granted, because the juvenile detention certificate follows the child to court. And it may be worth asking the court to comment on the decision contained within it. One of the circumstances where I think this is appropriate is where particular areas have got policies in relation to certain offences that don't cross the custody threshold when you get to court, and they don't really justify a request for secure accommodation from the police station, but nonetheless the police are withholding bail for them. And if this is repeatedly raised at court and comment is fed back to the police that make these decisions, then hopefully there is some sort of drip feed effect that may slowly change the culture of refusing bail for those offences. Thank you.
Thank you so much, Mel. Oh, don't know what's happened to my camera there. Right, well, I think it's particularly interesting to just hear the detail about how much work can be done to try and secure bail for children at the police station. I suspect, and it's certainly our experience of talking to kids who've been through it, that that's not always what happens. That's not all the, the legal representatives don't always put as much effort as that into it, and also even if they do, sometimes the children aren't aware of it. So really good to hear all of that detail. I'd like to introduce you to our next speaker, who is Sam Jacobs, a barrister from Doughty Street Chambers, who specialises in public law, civil actions against public authorities and inquests. Sam's work in civil actions against public authorities primarily arises out of interactions of individuals with the police, prisons, mental health care and social care, and he's regularly instructed in inquests, civil trials and High Court matters. He was junior counsel in AR versus the London Borough of Waltham Forest, which concerned local authority duties to provide secure accommodation to children in police custody who've been denied bail. So now I will hand over to him to tell you more about the law and that case in particular. Thanks.
Thank you, Katia, and good afternoon, everyone. I'm going to talk to you for the next 10 minutes or so about the legal framework which applies post-charge. So generally after interview and when a child has been charged with an offence. So the starting point is that set out in section 38(1) of PACE, which is that the presumption is that of bail on the which can only be refused on the bases that I've set out there, and Mel has just spoken to you about some of the representations that can be made and some of the practical considerations which need to be taken into account. So I'm not going to say too much about that. And if we move on to the next slide. So this is really the key issue which I'm going to talk to you about. Pursuant to section 38(6) of PACE, the custody officer must secure transfer of the child to local authority accommodation unless it's impracticable. And as Mel mentioned, the Home Office Concordat is very helpful in explaining just how narrow an exception that is. Or secure local authority accommodation is necessary to protect the public from serious harm. And again, that's a very high threshold, but is not available. But significantly, the very firm presumption according to section 38(6) of PACE is that the child should be transferred to local authority accommodation. And indeed, if non-secure accommodation is sufficient, then in effect the child must be transferred. If we look at the next slide, we will see that the sort of reverse of section 38(6) of PACE is section 21 of the Children Act 1989, which imposes statutory duties on the local authority to provide accommodation. And that was considered in the M and Gateshead case. The essence of M and Gateshead is that the local authority is under an absolute duty to provide non-secure accommodation in response to requests made by a custody sergeant and a duty to have in place a reasonable system to respond to requests for secure accommodation. So just to repeat a couple of basic but really important points. Where the request is for non-secure accommodation, the duty upon the local authority to provide it, to meet that request, is absolute. And absolute is the word taken from M and Gateshead. In relation to secure accommodation, the court in M and Gateshead considered that when one reads section 38(6) and section 21(2) together, it's not the case that the authority is under an absolute obligation to meet requests for secure accommodation, but at the very least, local authorities must have in place a reasonable system to be able to respond to such requests. And really quite importantly, what Lord Dyson explained in M and Gateshead is that that reflects the parliamentary intention that children should not be detained in police cells, save in wholly exceptional circumstances, and that both police and local authorities should be discharging their duties with that parliamentary intention in mind. If we look at the next slide, we can see that unfortunately, despite the very clear statutory provisions, they are, at least in some parts of the country, more honoured in the breach than in compliance. Save perhaps in some areas like Greater Manchester, and it was good to hear of the steps that Jackie has taken with her colleagues. But these are some some statistics from the Metropolitan Police in 2018, and sorry to be London-centric, but in that year, there were 356 requests for non-secure accommodation, and 53 were met, which is about 15%. And just to remind you, there is an absolute obligation on local authorities to provide non-secure accommodation when it is requested. But in 2008, it actually met the request in about 15% of times, and that is the position which is consistent across recent years. It's a clear breach of duty, and perhaps some steps can be taken by way of representations of the sort that Mel described. But also, I think, consideration can be given to claims for damages on behalf of children who are unnecessarily detained in a police cell rather than in non-secure local authority accommodation. And it may also be that individual claimants could consider judicial reviews of local authority systems of the sort that we will consider in a moment. If we go on to the next slide, unfortunately, there's a typo in this slide. So in 2018, there were 342 requests for secure, it should read secure, not non-secure, 342 requests for secure accommodation, and one was met. And I suspect, for reasons that will become clear in a moment or so, that one was probably a statistical error, and the number is probably 0. But that is the position across London. There's really two things that can be drawn from those stats. One is that there are far, far too many requests for secure accommodation. So we can see, looking at the stats for both secure and non-secure requests, that almost half are for secure accommodation, notwithstanding the very, very high threshold for secure accommodation of a risk of serious injury to the public. And the second point is really that quite clearly across London, local authorities do not have a reasonable system for meeting requests for secure accommodation. If we go on to the next slide, Just for Kids acted for a young lad who had been held in a police station overnight, with the local authority having failed to meet a request for secure accommodation. And a judicial review was taken on his behalf, which challenged the adequacy of Waltham Forest's system. And the context, which is relevant, is a nationwide, very, very serious shortage of secure accommodation. Across the whole of the country, there are 15 units, and that's not 15 units to meet Section 38 requests. That's 15 units to meet the demand for secure accommodation in all contexts. So that is local authority children's services who want to place a child who needs it for their welfare. For justice placement, so when it's requested by the court, and in response to Section 38(6) requests. And the problem is so severe that you may have seen a recent Supreme Court judgment dealing with the question of what a court should do when a local authority is resorting to using unregulated placements, just because there's no secure accommodation available. But in any event, Waltham Forest, perhaps surprisingly, defended the claim, and they did so on the basis that it did have a reasonable system. Its reasonable system was that it can answer a phone call from the custody sergeant, it can consider the request and can send a request for secure accommodation, albeit that the answer will always be no, realistically. It didn't quite accept in the hearings that the answer would always be no, but it became apparent that the closest unit to London for secure accommodation in response to Section 38(6) requests was somewhere near Manchester. So they accepted that there was no prospect at all of a secure placement during the week, but said that perhaps if a child was charged shortly after Saturday court closed, they could be sent 4 or 5 hours up to Manchester, and they could leave Manchester at 4 o'clock in the morning, Monday morning, something like that, so that they can be produced at a London court on Monday morning. I mean, really absurd stuff. If we go on to the next slide, actually, Waltham Forest did succeed in the before the divisional court, but we appealed to the Court of Appeal, and the Court of Appeal was satisfied that the system was inherently likely to fail, in the sense that, as a matter of routine, the answer to a police request would be no. And surely, sensibly, the Court of Appeal said that cannot be a reasonable system, and it is in breach of the statutory duty and importantly, the statutory purpose that children should not routinely be held in police cells. There is some fairly nascent work, pan-London work across the London authorities to try and source some secure accommodation to meet Section 38(6) requests, but it really is going at a snail's pace. And in fact, when one looks at the detail, it doesn't seem to be focused on Section 38(6) requests at all. So in a sense, the picture is a fairly depressing one, although it's encouraging that the Court of Appeal made the finding it did, and hopefully that will stir authorities into action. It's also perfectly evident that the vast majority of authorities actually across the country take a very similar approach to Waltham Forest and are probably also acting unlawfully. So if you have clients who are held in police stations with local authorities not providing non-secure or secure accommodation, and they're not doing that as a matter of course, then it is worth considering the possibility of a judicial review. That's what I have to say on post-charge legal framework. Thank you.
Thank you very much, Sam. It's really positive to hear about how this issue has gone that far and the success of that case. I'm now going to introduce you to our final speaker, who is Jennifer Twight. Jen is head of the strategic litigation team at Just for Kids Law and a practicing barrister since 2006. In 2016, she and her team launched the No Child in Cells campaign, which takes a number of related challenges against local authorities across London, including the Waltham Forest case you've just heard about. And through the Youth Justice Legal Centre, she has also been training the Met and local authorities on their duties concerning the rights of children in the police station, as well as engaging with a range of stakeholders on the issue, such as the National Police Chiefs Council, National Police Chiefs Custody Forum and MOPAC, all working towards pushing for a more child-friendly approach at the police station. Jen, can I hand over to you?
Hi, thanks, Katia. So I just wanted to briefly talk a little bit about the No Child in Cells campaign, although I just realised in my bio, Katia has just basically already given you a summary of what we've been doing. I don't have any slides, by the way, so if you can't see slides, that's not a mistake. I will be speaking without them. As Katia just said, part of our campaign has been greatly assisted by both Sam and Keelan, who have been counsel for us in some of the challenges we've taken, like the recent case of Waltham Forest. So we started the campaign in 2016, so it's been running for 5 years now. And the focus of it has been very much keeping children out of police cells. I want to start by just talking about what the problem is, and also emphasising that it is a problem, because it's really nice when I do events like this and everyone starts from the assumption that being in the police cell is damaging for a child, but certainly through some of the work we've done, I don't think it's always universally acknowledged how damaging it can actually be. And certainly I speak to a lot of police officers, some of whom coming from a really good place, but still will tell me how children are safer in police cells. They're warm there, they're fed there, they're not going to get stabbed by the local gang, and they see it as a really protective environment. I also think that police station reps who are in and out of the police station don't always think that a night or 2 nights in the police cell, when there's so much else going on in a kid's life, it is that big a deal. And in addition to that, we've seen, and as Jackie alluded to, a lot of good work actually across the country about making cells more child friendly. Certainly it's not just Greater Manchester. I know that in the Met and other places across the country, we're seeing police bringing in more books, more fidget toys, trying to work out how to make a cells a more child friendly place. There's an initiative going on in London where they are trying to turn it into a more positive experience, where the idea is that when children in a police cell, this might be a time when they're particularly open to speaking to like an outreach worker about the problems in their lives. And the phrase that's used is the time in the police cell may be a reachable, teachable moment. And whilst it's really positive to make cells more child friendly, it does concern me that sometimes that confuses especially custody sergeants, with the idea that maybe these cells are a positive experience, and dilutes the idea that they should only really be kept there when absolutely necessary. Because despite the fact that children may be fed when they're in police cells and may be given a book nowadays and might even speak to a night outreach worker, it's still very much the view of Just for Kids that it's important to keep them out of cells as much as possible, and really work to what Jackie was saying, which is great that Greater Manchester are doing that, in really trying to make sure that kids just aren't in police cells at all. Because whatever we do to improve the experience, I don't think you can take away from the fact that being locked in a police cell is just simply unpleasant for anyone, let alone a child. In some of the trainings I've been doing, I have been asked quite a lot, especially by custody sergeants, about what the problem is. What is do children want? What can we fix? How can we make ourselves a nicer place so children are less traumatized? And whilst again, I say there is stuff that can be done to do that, essentially, I think what most children I speak to want is the freedom to leave. They don't want to be detained and they don't want to be around police officers. And there's only so much you can do to fix that. And of course, as is put out in the guide, and as you've heard from other speakers, and as I'm sure a lot of people already know, you can only be detained in a police cell if it's necessary, and that should be a high threshold where it's necessary for that detention to secure or protect or preserve or obtain evidence in relation to the offence. And that, of course, is true for all detainees. And in addition to that, when we're dealing with children, we have those extra duties owed to children, like as Mel mentioned, Section 10 of the Children Act. And again, as is set out in the guide, we have guidance from the College of Policing saying how important it is to make sure that detention is absolutely a last resort for children. So the children we speak to do tell us that it's a distressing experience being in the police cell. One of the things, again, won't be a surprise to anyone who deals with children regularly, is that they don't always tell the police officers, their parents, the appropriate adults, their lawyers, what an unpleasant experience it is at the time. But certainly when they are given the opportunity to talk about it, it is an experience that they often describe as very distressing, especially for those who do it who are regularly detained. They talk about how boring it is. One of our clients used to say how it was just like being locked in a disabled toilet for 24 hours. And some of the custody records that I've read talk about children pacing up and down, talk about them banging heads, and sometimes, obviously, in extreme circumstances, a lot worse going on. So we do think it's a problem, and we do think taking children out of police cells and reducing the amount of time they spend is really necessary and worthwhile. But in practice, it is our view that a lot of children are detained unnecessarily in police cells. And when we started the SEC campaign, we did look a lot at the statistics, some of which had already been gathered through FRI requests by the Howard League, and we've done an awful lot of our own FRI requests over time. What we found was that if you go back to sort of 2014, 2015, over 100,000 children every year were detained in police cells overnight, spent a night in a police cell or more in a year. Now, that number, thankfully, has gone down quite a lot, as it have things like the arrests of children and the number of children entering the criminal justice system generally. And we have seen a much more child-friendly approach to policing over the last 5 or 6 years. But whilst those numbers have dramatically decreased, we are still seeing tens of thousands of children held overnight every year in England and Wales in a police cell. And the story that those numbers tell is that this is something that happens routinely, that a child spends a night in a police cell. It's not the case that this is just children who have a lot of experience with the criminal justice system. It's not the case that this is something that happens in exceptional circumstances where there's really no other option. It is very much a matter of routine. And certainly that's my experience from, I say, looking at custody records, speaking to children. And I've spoken to 13-year-olds, 14-year-olds, 15-year-olds and their parents about their experiences of being in a police cell for 24 hours, many of whom it was their first experience of ever being arrested, some of whom were arrested for quite minor offences. I had a 14-year-old arrested for shoplifting, who ended up spending 2 nights in a police cell, many of whom got NFA'd at the end of the experience. And so their experience of the justice system is, as I say, at quite a young age to spend, for them, quite a long period of time in a police cell. And I particularly remember speaking to a mother of a 15-year-old girl who had been arrested for the first time following a fight after school, and she was eventually NFA'd. And because by the time they got to the police station, it was late in the day, the mother was eventually told to go home, and they would interview her daughter the next morning. And what really stuck with me was how indignant the mum was. She just couldn't believe it. She just said, "But she's a child. What do you mean? You can't?" She just didn't believe that the police were allowed to hold her daughter in the police station overnight. She genuinely didn't believe that was a possibility. And I think a lot of parents probably, if confronted that, would feel the same. So I do think that it's important to recognise that this is a really damaging experience. I also think that we all become immune to our own environments some of the time. When we train barristers, we talk about how I often think barristers don't see how intimidating a court is for a witness. And I definitely think that a lot of custody staff don't see how intimidating their police cells are for children, and they see them as safe places. So that's really a lot of why we felt that this was a really important thing to do, and we felt the numbers were very high, and that really, as I say, that this really felt like a matter of routine, where it really should be quite unusual for a child to have to undergo an experience like this, and quite unnecessary that the status quo is as it is. Our focus at the start of the campaign was very much on Section 38(6), the transfer of children from police stations to local authority beds. And Sam and Mel have spoken quite a lot about this, about what the police duties are. I'm not going to repeat that. One of the reasons we were particularly interested in that particular point was that, as Sam's made really clear, there's an absolute duty on local authorities to take these kids. The numbers of children who are not transferred are really high when it should be zero. All children should be transferred to local authority accommodation. So one of the things we did at the beginning of this campaign was try and look at why that wasn't happening, and try and understand what was going on and how we could improve the situation, or help to improve the situation. And I used, before I was strategic litigation at Just for Kids, I was a criminal barrister for years, and I've represented many children at court, many children in the cells, and I've never, at that point, I had never once seen a child transferred from the police station to local authority accommodation. All the kids I represented who had been denied bail came to the cells, and I spoke to other lawyers who were saying exactly the same. They'd never seen a transfer. And actually, if you look back in London, certainly where I was practicing, at the statistics from sort of 2014, 2015, it was close to 0%. Sam's just expressed outrage that 15% of children are now transferred, and I think it's possibly up to 20%. But if you go back a few years, it was close to 0% when transferred to local authority accommodation. And it's interesting hearing Jackie talk about how the HMIC report really kicked Manchester into action, because there were people complaining about it. There were that HMIC report coming out saying, why is this not happening? Why is there a problem? And there were other reports from the Howard League, from the National Association of Youth Justice, really going on about how this was a massive problem. But I think for a lot of local authorities on the ground, no one was challenging them. And when you spoke to police sergeants, and in fact, if you read the HMIC report, it talks about the fact that local authorities just never some local authorities just never accommodated children. Some police were stopping even calling a local authority, or treating it as a tick box exercise, because they were never getting through. They were never getting a child transferred. And so for us to start with, this was quite an unusual campaign, because a lot of the campaigning work that we've done is about trying to change the law, change the policy to improve it. Whereas here we had a situation where the policy and the law is actually quite good. It says that children shouldn't be held in cells. It says it gives a framework for children to be transferred, but it simply wasn't being adopted. And so our campaign became much more about raising awareness and trying to work out how we make people start looking at the problem. And so one of the things we did, which as Sam has alluded to, is we took a number of judicial reviews, and we took complaints, and we took cases to the local ombudsman, and we think in total we've so far challenged 9 of the London local authorities, and certainly a lot of them we've spoken to who we haven't directly challenged, in attempt to try and be those people who made a complaint, and to make it more difficult for the duties to be ignored. In addition to that, we've done a lot of media work on the issue. We've been training local authorities as well as training the police. I think it's important to note that there has been improvement in the last 5 years, as I've just acknowledged, that when I started doing this work, we were looking at 0%, and while we shouldn't be having in London only 15 or 20% of children transferred to local authority accommodation, it should be much higher. It's still higher than it was. And there certainly seems to be an awful lot more awareness. It's not just us been working the issue. We've done lots of, Jackie's been talking about the great work in Greater Manchester, and I know there are a lot of other people pushing for this issue to be taken more seriously. I've only got about 30 seconds left, but I want to make one final point, and that is that when I started talking about how problematic it was for children to spend a night in the police cells, and we've done a lot of work, and we've been talking a lot about children being transferred to a local authority accommodation under section 38(6). But that's not the only reason children spend a night in the police cell. And in fact, when we started looking at the statistics and drilling down into them, one of the things we discovered is the majority of children who spend a night in the police cell are not doing it because there's a failure to transfer them. The majority are there because the investigation is ongoing. The police haven't interviewed them yet, or they're still gathering other evidence. And it's just like Mel was talking about, how they get bedded down for the night. And there's another large group of children there who are there for breach of bail or arrested on warrant, where section 38(6) doesn't apply. And so going forward, one of the things we're really looking at is how we reduce those numbers. And a lot of that is about challenging the police, and that's really some of the great stuff that Mel was saying about how you challenge the police to make sure that child is expedited through custody. Do you challenge the custody sergeant about whether or not they really have grounds to detain? Can that child be bailed and come back for a voluntary interview? And all those questions that we'd really pushed to be considered. And there is support from that in police guidance. There is that, and I hope the guide is useful at the beginning when it talks about pre-charge, in helping empower those in the police station to push for that. Because that is also where a lot of children spend an awful lot of time, in which we think could be massively reduced if more thought went into it. So I just wanted to end with a plea, though, to any of those who are working in this area, whether doing so as a police station rep or a youth offending team or police officer or any professional, to contact us, to contact me particularly, because we are still working in this area. This is still an ongoing campaign. I still feel that there's an awful lot of stuff that can be done. And we're very keen to be contacted with questions, with ideas, with potential cases that we could take, or cases that maybe if you want to take yourself and want some support in doing so. All of that is stuff we can help with. So please do get in contact. Thanks very much.
Thanks very much, Jen, and it is an amazing campaign which has achieved so much. And there is, Jen, her team, Sam, Keelan, and all of the. I've been at quite a few of the trainings that Jen's run, and there's been a lot of willing from all the different players in this area to kind of try and progress towards change. So that's been really great to see. Not that there isn't still a lot to do, but at least it's nice to see that kind of tangible change in our work. So we're going to move to Q&A now. So if I can just ask all of the participants to turn their cameras back on, that'd be great. And my first question is going to be for Jackie. It's a question from the audience which says, have other areas been in contact about rolling out your recent developments with regard to best practices for young people?
Yeah, we have had other areas contact us, but equally we've contacted other areas because there's a lot we can learn from other areas. As Jen referred to, I'm just talking about the Greater Manchester experience, but I know there's some really good work, and it's about building on that best practice, really. But I know as well that police colleagues have been doing a lot of work nationally and talking to other policing areas as well about what work can be done. So yeah, I think it's a shared experience. And that, I don't think anybody's got it right, but I think some people have got it better than others. So let's kind of build on the best practice. I noticed as well, I know you're coming up to it, there was a question about numbers and transfers under pace. I think there was quite an early question on that, which I'm sure you'll come to, but it was one worth reflecting on.
Okay, all right, thank you. Mel, another question from the audience. How are we supposed to conduct all of these pre and post-charge inquiries centred around bail under legal aid or prior to legal aid being granted? Most firms will not authorise all this additional work, and the fixed fee at the police station doesn't cover all this work.
Well, pre-charge is fine. It's covered by advocacy and assistance pre-charge. If you are looking at dealing with bail conditions being varied and things like that. If you're talking about the amount of inquiries that you need to make to get a bail package put together, then I think any police station representative knows that whether or not our fixed fee is sufficient, we do it anyway. Where the separate funding kicks in is where you're looking at getting the full custody record and the certificate of detention, because you're getting that with a view to considering judicial review. And that would be eligible for legal help claim. And you generally you fill out the legal help form at the police station with the client, and then you can sort out funding for emergency judicial review after that. And of course, there is the provision for a certain amount of work to be done once you're making an application for legal aid. Work undertaken in the hours leading up to that application can be claimed under that order as well.
Thank you, Mel. The next question is another question from the audience, this time for Sam. Did the Court of Appeal rule that the lack of secure accommodation for children in London was unlawful? Can you just go back over that point and clarify, please?
So what the Court of Appeal said is that Waltham Forest did not have a reasonable system, and so it was in breach of its statutory duties under the Children Act 1989. So in that sense, the ruling was focused on Waltham Forest as it had to be, because Waltham Forest was the defendant, because the statutory duty doesn't apply across London. It applies to each local authority individually. But it is perfectly evident from, in fact, the judgment that all of the London authorities, or at least most of the London authorities, take the same approach. And in fact, part of Waltham Forest's response to the claim was to say, we can't be acting unlawfully because we are only doing exactly the same as what everyone else does. The answer is that in the technical legal sense, it's Waltham Forest in relation to whom a finding of unlawfulness was made. But in practical terms, it is clear from the judgment that there is a problem right across London, shared by all of the London authorities. And I noticed in one of the comments that it sounds like some really great work is happening. I think it was in Hackney, with some discussions going on with the police. And I think that sort of initiative seems to me to be really important in practical terms. And something that struck me, and Jackie, maybe you're able to tell me if this is wrong, but I certainly read a case study in relation to the work done by Greater Manchester Police, and for a period the Chief Constable of Greater Manchester Police spoke to the custody sergeant after every request for secure accommodation, and that in itself, it's amazing what the prospect of a discussion with the Chief Constable means for deciding whether a child actually does need to go to secure accommodation. And that in itself led to a drastic reduction in the number of requests for secure. So yeah, there we go.
Thank you. And there was just one.
Shall I just answer to that? Sorry. There was a great deal of scrutiny, particularly after the HMIC report came out, and it wouldn't surprise me if the Chief Constable wanted to look at every request for secure. I wanted to reflect on something you said yourself, Sam, which was around the amount of times that the police are actually asking for a secure. And then I think we are then dependent on our out-of-hours colleagues, our EDT colleagues, to be challenging that and saying, well, actually, no, we can do a transfer under PACE into a non-secure bed, because that is our experience as well, that there is a default position with quite grave crimes where a secure bed is asked for, and you have to have some very competent out-of-hours workers. It does tend to be out-of-hours who are challenging that. And that's why we provide training to our out-of-hours colleagues as well. And, you know, we are fortunate in Greater Manchester because we do have a really good secure children's home in Greater Manchester. You know, it's consistently outstanding, but those are welfare beds, you know, those aren't they're not our right to use them. We still have to apply, and we had to do a lot of work to make some very good relationships with our local secure children's home, so that they would work with us, that, you know, if a child needed to be transferred, they are. So we get a list every month, and on that list, it's quite, you know, because the numbers are now low, it's which custody suite was it, what child was it, what ethnicity, what was the crime, who was the arresting officer, who was the custody officer, who, what was the request, why was that request made, what was the local authority response, you know. So we're kind of going through what was a non-secure PACE request, and we've been fortunate enough in Greater Manchester now to commission a Section 38 bed, which is available for all the GM authorities. But that has come as a result of these discussions, you know, because as I said, we didn't have any. So that list is also looking at anyone who's a child that was an overnight detention, and then did we do everything we should have done? And sometimes we do and sometimes we don't, but that's how we learn.
Thank you. Jen, there was a question from the audience. Do you feel that the Pan-London vehicle will solve the lack of overnight custody beds in London?
I know very little about the Pan-London vehicle. Sam alluded to it. I've been trying to find out what's going on. So if anyone knows, I don't think I can really answer, because despite efforts.
Sorry.
Oh no, go Sam.
I was just going to say that the evidence that was put before the Court of Appeal was that the London councils together had done some very preliminary work looking at costings for some secure accommodation, with a view to making a submission to the Secretary of State to ask for funding from the Secretary of State to assist with the cost of secure accommodation within London. It was at its quite early stages, and the proposal was largely focused on meeting the need for welfare placements and for justice placements. And in fact, there was no reference at all to Section 38(6) requests. But I mean, hopefully the Court of Appeal judgment will be taken into account going forward.
Yeah, so I mean, but on that, if that's what's happening, which is that we may get some secure accommodation in London, that would be amazing, because it means that, because at the moment, if all requests for secure accommodation in London are just not met at all, they can't be met. So all of those children will spend a night in the police cell. So if that works and that's met, then that solves that bit of the problem. I say it solves it. Obviously, it depends how many beds are on, whether there are enough, etc. But it would help solve that bit of the problem. It doesn't solve the non-secure beds. It doesn't solve all the other things we've talked about children spending night in police cells due to being investigated. So it's a part of the puzzle that hopefully might improve.
Okay. A more sort of practical question from Mel. Is the YOS available to request a copy of the full custody certificate and the juvenile detention certificate?
Yes, the juvenile detention certificate is available at court. The full custody record is available from the police. The police are meant to inform the local YOS when they have a child in custody. So I can't see any barrier to the YOS obtaining a copy of the custody record.
Thank you. There's a question for Jackie. Sorry, let me just get that. A question from an audience member who is someone who grew up in care and asks, why is there not more responsibilities and duties placed on the local authority to provide alternative accommodation to children that are being detained in cells?
Well, the duty does sit with the local authority, that's the point. So it's not, you know, the duty is there, it's in law. It's down to the local authority to implement that. So, you know, it's not really why, but how. I mean, we have talked about the sort of the paucity of secure beds, and that's absolutely true. And that's not just for welfare remands, but also for criminal remands as well. And it hasn't been helped by the secure training centre reports that have come out recently, where which have not been, have been found inadequate. But there are some excellent secure children's homes, but that's a last resort. And I think the point is there might be many opportunities and instances of children being transferred under PACE, which we don't hear about, because actually that arrangement is made and there is no request for a sort of a secure bed. So I think, there are some hidden figures there, whilst I also accept there's some hidden figures on bail and warrants as well, because obviously it's different guidance. But I think there's some hidden figures where the arrangements are just made and that child is transferred. So I mean, just an answer to your question, it was Roxana, I think, that it is the responsibility of the local authority, and beyond that, it's already in law, and why wouldn't we are doing our best to enforce that.
Thank you.
Sorry, could I just come in very briefly?
Yeah.
For the potential interest of those who do have discussions with police forces about concerns on this issue. In fact, because of the mandatory nature of the duty upon local authorities to provide accommodation, to provide non-secure accommodation, the statute also provides that if non-secure accommodation is not provided, then police forces can charge local authorities for the cost of providing a night of accommodation. And in terms of carrot and stick, that's potentially a useful stick to encourage local authorities to meet its duties.
Thank you. Mel, when looking at local authority accommodation, non-secure accommodation, is the child's home address considered sufficient as non-secure accommodation? If parents are able to offer sufficient oversight of the child?
The great thing is that once the police have transferred a child into the care of the local authority, the police have no say over where that child can be placed. And if the local authority deem it best for the child to return home, then the child returns home and can be subject to less conditions than a bail package that's proposed with the child returning home by a solicitor trying to get their client bail. So yes, a child's home can quite easily fit the definition of non-secure accommodation.
Can I just comment on that? Because you're absolutely right, Mel, but actually what we find is that's one of the areas that our police colleagues struggle with most of all, which is you've made that recommendation, now leave it to the local authority to make that assessment. And if our assessment is that child needs to return home to we generally don't have a bed that says PACE in it, in bright lights. That PACE bed, that transfer under PACE, might be with Auntie Joan or whatever, but basically we've made that assessment and we are undertaking to say, based on our professional assessment, that is a suitable placement, and we will also undertake to get that child to court the following morning. I don't know how others, it is in other authorities, but I know that is, because I've provided training as well, that is one of the big sticking points of, but I've said this child needs to stay here, or, and how are you going to ensure that child doesn't climb out the window is my usual response that I get. And I said, well, if you can show me evidence of how many children have climbed out of the window when we've transferred them under a non-secure PACE arrangement, I said, then I'll look at that. They rarely can, as Jen said, children just want to get out of custody. And if you are giving them that option to kind of go to home or wherever, they tend to comply. Not always, but in our experience, others may disagree. They tend to just go home to mums and turn up at court the next day.
Well, not quite the same, but linked, a question for Jen from someone who works as an appropriate adult in the London area. What, in your view, is the most effective, succinct argument or piece of evidence that we can make or refer to for custody sergeants to counter their default position that it's in the child's best interests or safety to be kept in custody, as opposed to having a voluntary interview, for example? From personal experience of the Met, they instinctively reject the idea that it's more damaging for the child to be detained in the first instance, unless you can give very concrete reasons as to why.
So I spent a lot of time talking to the Met. And yeah, I find this one of the most challenging things, is that I come across a lot of custody staff who will say, I don't care, I don't want this child to be released and be stabbed, and then have the moral and legal problems of that having happened. And that's more important to me than comply with my legal duties. And that is one of the most difficult things to combat if people really think that way. I think that if you're arguing for, I suppose what I try and do is point out that's not their role. You know, that you can't safeguard a child 365 days a year by keeping them in police custody. You know, so their role can't, you know, it's a very, I find it a very odd idea that, oh, this child might get stabbed one day, therefore I'll keep them in custody for an extra 8 hours. It's not a long-term solution. It's not really a particular solution at all. I think also a lot of custody staff worry about what their obligations are legally. And so I know I've spoken to Jackie about this before, the importance of explaining to the officers that actually their duty is to keep them in custody as little as possible. You know, going back to what Pay says about detention being actually necessary, going back to the definition of secure, and pointing out that it's not, you know, it's not their duty to just sort of generally safeguard the child from all ills that may befall them if they're out in the outside world. Because I think there is a lot of concern that if they release them, that something's going to come back on them. You know, a lot of concern when you were talking about going home, a lot of concern that if they run away, that the police might get into trouble, which isn't what the law says. The law says that police duties cease once the child is transferred into local authority accommodation. So sometimes it's about, I think, ensuring that they understand what their legal duties are. And in understanding that if they're transferring them to local authority accommodation, their police duties cease. If they're releasing them to voluntary interview, that is perhaps what's legally necessary to do. But I think it's a tricky conversation, so I'm not sure I've really totally answered the question, sorry.
No, thank you. And I don't know, Mel, if from your perspective of advocating actually in the police station, you have anything to add to that?
No, I suspect I've been in many of the custody suites that the appropriate adult has been in, and simply getting the police to recognise that we are dealing with a child is, quite frankly, hurdle enough sometimes, let alone one that has to be treated differently to an adult. So I don't actually have that much to add to Jen's comments.
Okay, there's another question for you, Mel, which is it possible it might cure kids? Oh, sorry, I just lost where I am there. Is it possible it might cure kids being detained overnight for morning interview if there's an express obligation underlined to the inspector on reviews asking them to record explicitly reasons for the delay before interview, and why alternative bailing at 9 AM return is unsuitable?
Well, I think now is probably a very good time to acknowledge that actually getting the police station to answer the phone is a challenge. So, you know, I'm not kidding anybody. Getting answers out of any of the police is hard enough sometimes. But in theory, you can challenge any decision made by a custody sergeant to an inspector. And there have been times where I have tried to hound the PACE inspector to reverse the decision to keep a child in overnight. I think that the inspector's review decision implicitly makes it incumbent on them that they should be saying why detention should continue overnight, and it should give a reason. But I think many of these reviews are conducted over the telephone or when children are asleep. There are very few occasions on which I'm actually called by an inspector to see if I've got representations to make at the review point. And sometimes you have to be extremely diligent to remember roughly when to call and leave representations, because the chances of speaking to somebody who's making the decision is quite slim. But yes, I think it should be incorporated into the regional protocols. If nothing else, the inspectors should make a note of that.
Thank you. Sam, what kind of things are needed to make it a reasonable system to enable the local authority to respond to requests under Section 38(6) of PACE for secure accommodation?
Yeah, very, very good question. In Gateshead, so that was the case that happened some time ago, 2006, if I recall correctly. The court on that occasion did say that local authorities do have a fairly broad discretion in deciding what its system will be, acknowledging that secure accommodation is expensive. And the court will be unlikely to declare it's unlawful unless the system is unable to meet requests at all, in essence. And so Waltham Forest is acting unlawfully, and the Court of Appeal was willing to say it was acting unlawfully because in practical terms, it could never meet a request for secure accommodation. But frankly, if, well, perhaps I should be careful what I say, but there is a limit to what the statute requires, if I can put it that way. And I think some secure accommodation in London would probably meet the duty, even if it didn't mean that all requests could be met.
Thank you. Jen, another question asking about the campaign, the No Child in Cells campaign, and have you engaged with directors of children's services, national and local networks? I'll just read an additional comment that came in with the question, which says, in Hackney, we've been applying a concordat approach with police for 5 years, and in a similar way to Greater Manchester's experience, we review with the police each incident where a child has been held in police custody overnight or the weekends. Knowledge of PACE and the Children Act has shown to be lacking on both the sides of the police and social care. Has the campaign engaged with directors of children's services?
We have, I'm trying to remember because I've spoken to a lot of different people, and off the top of my head, I don't always remember every single meeting I've had. We were speaking to someone from the Association of Directors of Children's Services, and we were trying to we've been trying to go to a meeting with them, but I don't remember what's happening. It's one of the things I need to chase. So yes, we have been trying to engage with them, but we haven't done a huge amount of work, but we'll be very happy to engage further. In the Waltham Forest case, the Association of Directors of Children's Services and London councils were both interested parties in the case and put in some evidence about what they were doing, but not loads. So there's been some limited engagement. But if you're doing good work in Hackney, maybe send me an email, because maybe we should talk further, because it'd be really interesting to know what you're doing and what if there's anything further we can do.
Okay. More technical question from Mel. If a child is refused bail at the station, granted bail at the youth court, the magistrates court, and then the CPS launch an appeal, should a secure bed be sought rather than automatically being remanded until the appeal date?
Once charged in at court, then there are different considerations than we've been discussing here. It's whether or not there's a remand to youth detention accommodation overnight or remand to local authority accommodation. So it's a completely different test. It's a little bit similar, in fact, to when a young person arrives in the youth court charged with murder. The court still has to decide whether they're detained for in youth detention accommodation or in local authority accommodation, and then you look at the LASPO provisions.
Thank you. Sam, what sanctions can be imposed upon local authorities that fail to meet their statutory responsibilities?
Yeah, it's not easy, and to a degree, the statutory obligations, though clear, are relatively toothless. I think the sanctions that can be applied is a declaration of illegality by the High Court, which carries some weight. In principle, as I mentioned earlier, the police service who have held the child in a cell because the local authority hasn't provided accommodation can charge the local authority, and potentially a damages claim, as I also mentioned earlier. I think those are the three things that can be considered.
Thank you.
Can I also just add, you can take complaints against local authorities through their complaints procedure and eventually to the local government ombudsman, which is what we've done, which is essentially just a way of getting a damages claim, and that's essentially what Sam said. But that's one of the things that we have done successfully.
Jen, there seems to be a lack of understanding within custody suites between when to use secure and non-secure. Anytime a request is made, it's always for secure, which is very different to what's actually needed. It seems basic, but might it be possible to have some guidance from Just for Kids and the National Appropriate Adult Network on the difference so that our appropriate adults can challenge appropriately?
The National Association Adults Network have an amazing flowchart, which is, I think, footnoted in our guide, that Chris Bath wrote years ago, and is still like the go-to document on how to deal with PACE beds in the police station. I'm certainly happy to try and elaborate that on a document further, but I mean, I think, you know, Sam covered the law really clearly, and it's a really high threshold. It's about secure harm. There's a couple of points I think often missed. One is it's that you're looking at the risks the child might pose between them being transferred and them going to court the next morning. So when a police officer says, oh, he might stab someone, it's, well, will he stab someone between now, midnight, and when they go to court the next morning? Because that's the period of time you're talking about. And then it is just that it's a really high threshold. It's serious harm, that they're going to cause someone serious harm. So that is GBH level harm. And if you don't consider that, you can't. Sorry, go, Jackie.
Sorry, I was just going to say, and it's covered in the guide as well.
Yeah, it's in the Concordat, to be honest.
Yeah.
So I mean, I would really look at and actually our guide. What am I talking
exactly.
About? The guide. please read the guide that we've just published, which has reference to the flowchart, which has reference to the Concordat. If you want to look at those documents too, and hopefully that will help.
Thank you. Yes, we will be just plugging the guide throughout. And Jackie, we've only got a few minutes left. But Jackie, how did Greater Manchester address disproportionality and unconscious bias in decision making?
Yeah, I saw that one in the chat. I'm not sure we have put things in place which will challenge that. So I mean, there is no one kind of slick answer really. We make sure that when we're looking at all the cases where a request has been made, that we do break that down into looking at disproportionality, and there's no escaping the fact that the numbers of black young males that come into the custody suite is higher than any, you know, it is disproportionate. It's disproportionate in the courts and it's disproportionate in the police cells. So we monitor that really carefully, and then we obviously challenge that back, not just with the police, but with the wider criminal justice partnership. We address that within our training, because obviously there is that kind of unconscious bias, and we will be looking, you know, we look at that within our training models. And as I said, it's not just for custody suite officers, but it's for everybody involved in that decision-making process, either up to getting to custody and then post-custody as well. So, you know, I think it's something that we're really aware of. We've asked GMP and they provided some really good and up-to-date information around their data in terms of ethnicity in particular. And I think it's just constantly asking questions, constantly training, constantly learning, going back, revisiting it, learning again. As I said, there isn't one answer for that. I just think it's something we all need to be aware of and then make sure that we address it in our training.
Thank you. Well, that brings us to the end. There was one last question, which was actually for YJLC, which was, can we please have some training on the court process, bail and remand? Yes, you can. Just send us an email and, you know, we'd be really happy to talk to you about that. So thank you so much to the speakers, both for your help with the guide and for answering the questions today. This is the series of guides that we are producing together with the Children's Rights Group at Doughty Street. They're all available, well, all the ones up to number 8, which is today's one, are all available on our website. We publish one every couple of months, so we will see you back for the next time. Any questions about this or any of the other youth justice topics, please do feel free to get in touch with YJLC. And thank you very much.